Okay, we will call the meeting to order of the Mobility Stakeholder Group. Let's start with a roll call.
Dominic Franzella.
Jose Campos.
Joe Petito.
Katrina Salazar.
And with that, we have a quorum. Let's proceed to item 1, approval of minutes.
Motion to approve.
Got a first from Mr. Franzella, second from Mr. Petito. Any questions, comments? Any comments from the public? Call for the vote.
Okay, Jose Campos,
Yes?
Dominic Franzella,
Yes.
Joe Petito,
Yes.
and Katrina Salazar.
Yes.
With that, motion carries. Topic 2 is discussion and possible action regarding the ongoing role of the Mobility Stakeholder Group. And maybe we'll start with an update from Mr. Franzella.
Absolutely. So I'll just provide a brief overview of MSG item 2, the ongoing role of the MSG. This is the third time this has come before the MSG and CBA. Originally, it came in 2017 as the MSG and CBA were finalizing the mobility report, at which time there was discussion about ensuring that there was some level of continued oversight, state-level oversight of the mobility program that we included in our mobility report. And at the last meeting in January, the CBA discussed the MSG's ongoing role and approved a framework for the MSG's activity, which is outlined, I believe, on page 2 of your materials, and included maintaining the current authority and responsibility of the MSG to help ensure consumer protection, and directed to make recommendations to the CBA regarding the MSG's activities that would effectively monitor the CBA's mobility program, meet at least twice a year, and direct staff to draft legislation to update the BPC section 5096.21 subdivision E to grant the MSG authority similar to the CBA's other existing advisory committees, such as the Enforcement Advisory Committee, Peer Review Oversight Committee, and Qualifications Committee. So really the only remaining topic before the MSG, or before the CBA, relates to the ongoing evaluation of states' determination process that's prescribed in 5096.21. Much of the work that the CBA and MSG undertook between 2015 and 2017 dealt with doing these determinations, and MSG and CBA had engaged NASBA after NASBA's enforcement guiding principles of enforcement were approved by the board to then test that against other states' existing enforcement processes, as well as test for the disciplinary flag. That way states could continue to be in the no notice, no fee mobility program. And BPC section 5096.21 requires the determinations to occur on and after January 1, 2016, and it would, from staff's perspective, the use of this language appears to require the CBA not only perform its initial set, which it did, so it could include them in the mobility report, but that this also be maintained to ensure that states continue to perform in accordance with the requirements of the mobility program, so that it's not just a one-off process that we got them in there and we don't pay attention necessarily anymore to ensure that they're still practicing under those guidelines. So authorizing the MSG to coordinate and oversee these evaluations is one of the activities that the CBA could consider going forward. And the committee may wish to recommend to the board that it look at 2 additional kind of data points to assist in this. And these would be looking at whether states in a timely manner and adequately address enforcement referrals made by the CBA, and whether the state imposes discipline against licensees that is appropriate for the nature of the alleged misconduct. And these draw directly from the mobility language. And inclusion of these criteria provide kind of a practical application of the state's enforcement practice, because back then what we're really looking at is more implementation, less about some of the states were really just implementing those at those time, and there wasn't a lot of empirical evidence that we could draw on in order to assess whether or not they actually then put those into practice. And we stated as such in our mobility report as why one of the factors we took into consideration in selecting this alternative method. So staff believe that it's best that NASBA be the organization to assist the CBA and the MSG in doing this again. They obviously had some considerable experience in taking this on when we did the original determinations, And the CBA could authorize staff working with the MSG chair to kind of reach out to NASBA, gauge their interest in doing it again and willingness to assist. And this MSG chair and staff would request that NASBA provide basically a scope of work, kind of a methodology for conducting a state-by-state review, how and when to sample states, frequency of state reviews, evaluation of the continued disclosure of disciplinary information, a time frame for conducting the review, when NASBA plans to kind of expose and, you know, keep the guiding principles of enforcement, kind of an evergreen doc, not that it was a one-time issue, that it needs to be updated from time to time, or at least evaluated from time to time, and any additional information it deems relevant. And we would seek to have NASBA kind of provide some initial information by the board's July 2018 meeting. And this is primarily as Senate Bill 795, the Galligiani bill that's seeking to make mobility permanent, that we have some information to provide the legislature as that bill continues to progress. I'd like to really stress that what we're talking about here is not that NASBA is going to perform this by July 2018, that we're going to have this very structured plan, but really just to start that dialogue, have some methodology so we have something to kind of report back to the legislature, both during the Galligiani bill, but also as we go into sunset review, because mobility is likely a topic that we're going to have to discuss during the sunset review process as well. So it just arms us with some additional information on that state level oversight that the board's maintaining to ensure that states can stay in the no notice, no fee mobility program. So in the interest of some brevity, I'm not going to read the entire staff recommendation that's on page 5 because it's quite lengthy, but that's staff's recommendation. Primarily that we employ a similar process to what we did last time, that we include some additional data points, and that CBA directs staff to work with the MSG chair to kind of reach out to NASBA and gauge their interests. So with that, I'm turning it back over to Chairperson Campos, and I'm happy to answer any questions you may have.
I appreciate those highlights. The 5-page document really, I think, provided a very good overview of these matters. I would just highlight 2 things. One, the work around implementation that we were charged to do as a committee was completed and evidenced in that legislative report. And as you just alluded to, what we're talking about is a framework for the continuing evaluation that doesn't have a set completion date, but rather would be part of the spirit of consumer protection and the spirit of this particular law. Comments from the committee?
I have a couple of comments, Mr. Chairman. One, again, as always, thank the staff for the thorough job they've done. Obviously, put a lot of thought into this. Taking off on your point on consumer protection, one of the key aspects of 5096 is the board's ability to withhold a licensee from state ability to come in and use mobility. Very draconian penalty, but it's a penalty that the board can pursue. So, for example, if the board were to find that a state was not responding appropriately to a referral or referrals to that particular state, then the board, under 5096, has the ability to go through evaluation, use emergency rulemaking to revoke the ability to license each of the state. So I think that's important to keep that in mind. In order to effectively use that, we have to be able to, and I'm kind of leading to the next agenda item, have to be able to know how states are responding to our specific referrals. And I think that's key to maintain the protection of public interest. What is happening with all referrals to specific states? Are they being addressed in a timely manner? And there's criteria 5096 sets out. If there are enforcement actions by that other state-specific board, are they appropriate? And so I think the first level, kind of tranche of what we ought to look at and provide to the legislature, I think, is what is happening out there, what's going on now with our existing referrals, all these things. So that, to me, that's number one. And I know we could talk a little bit about the report. I love the next agenda. I don't want to get ahead, but the way that the report's structured, I think we get that information. It begs the question, though, since all work has been predicated around the NASBA model guidelines, guiding principles on enforcement, it raised the question of what's going to happen to those principles. So NASBA's told us, and this was a good thing, that they're, I think they called them evergreen. Their hope is that they continually they want to continually evaluate these enforcement principles and hopefully increase them. So then presumably the enforcement across the country will also be enhanced. So I think it raises a question. Do we, as the MSG and then the CBA, have an obligation to evaluate what's going on with the enforcement guidelines themselves, since everything is predicated off those guidelines? And I would suggest that that ought to really be the focus of staff's discussion with NASBA, and perhaps discussion back to the legislature is, what's NASBA intend to do with those guidelines? How is it going to keep them evergreen? In what aspects might they change? And so that's where I would look. I would be hesitant to go into a state-by-state analysis, again, it seems like ongoing, as the state's compliance with those principles, if we know that the process is working existing. So it's kind of like an audit. You're an auditor, aren't you, Mr. Chairman? I don't want to tell you what an audit is. It's kind of like an audit in the sense where, as opposed to auditing every single inventory item, you'll kind of take a sample. So my point with my unfortunately wrong point is to focus on the state-specific referrals that we're making, evaluate those first, and then per discussion with NASBA, then look at the principles as a whole, where they're going generally. And then perhaps that can inform what we might want to do afterwards. Thank you for your time.
So I think if I listen to the words there, that you're in agreement with the recommendation that's being put forth by staff, and you emphasize 3 points, referrals being one, the update of principles and at least making those continuously relevant. The third point around what do we do to oversee that or monitor that, I would think that that's part of the scope and work methodology that we would hear from NASBA in terms of what would they suggest, and we would have a chance to react to it at that point.
Yeah, thank you. I would not be as specific as staff is doing here with outlining these points. I would wait to have staff have a discussion with NASBA, to have them inform staff as to how NASBA is keeping current with the principles and the information that they get coming in. I think, we owe NASBA great thanks for the work it's done for us. And I think it might be straining NASBA, frankly, to keep asking them on an ongoing basis to monitor what every state is doing. When in fact, I don't think that's necessary. I think the primary indicator is what's happening with our referrals. I mean, that is that's the one thing 5096 says. It says, are states treating our referrals appropriately? I mean, that is the lodestone. And then anything else really, to me at least, is secondary. And so I would focus mostly on our state-specific referrals, how they're being addressed, are they being addressed appropriately, and then secondly on the principles generally as opposed to the state's individual compliance principles.
All right, so that's your view, Ms. Salazar?
I will throw in a few more comments. I do definitely support this. What I'm hearing you say, kind of as I'm processing all of these comments, I have a couple reactions. One is the feedback I received from various parties when I was able to attend NASBA events was that there was a benefit to having California have a requirement that helped NASBA reach out and helped other boards prioritize some of these tasks because of the impact of potentially not having the ability within our state because we are relatively large. So I would just point out that I would be aware that it could be helpful for us to set parameters at the point that we want detail. Hearing what you're saying, I would make a suggestion that we take this recommendation and on the third bullet point with requests for the minimum we're asking NASBA to provide, we step that back and give the staff more discretion to engage NASBA to develop those things, because I do agree we may not need to come in and say we want a stated frequency. I think we need to be focused more on the initial dialogue. So I would be supportive of taking out some of the bullet points, but keeping the spirit of the dialogue and collaboration between staff and NASBA to help develop what we would see at at a mid-year meeting.
So I'm actually, and I'm looking through those bullets now, so I hear the dialogue, and maybe it'll make sense to go through them individually here. Certainly that first bullet on understanding what a scope, work, methodology, that seems important, right? And all of these, by the way, are what we utilized in the first round of reviews, and so they're not coming out of the blue or different, they're consistent with that. The next two bullets on how and when to sample states and the frequency of state reviews sounds like maybe those could be deleted and allowed to be considered in the methodology concept. What framework do they have? We would certainly, be at the July meeting, could react to whether we think that's sufficient or not. The evaluation of states' continued disclosure of disciplinary information, I would argue that along with referrals, one of the big drivers of the mobility law was internet disclosure access of consumer information, which was a focal point of the initial reviews, and I would think that bullet point would need to stay as a very specific item that needs to continue to be evaluated, that information continues to be available. Time frame, that's important, I think we need that. And then everything's grounded on these guiding principles, so I think we need that. And then any additional information it deems relevant for CBA consideration, which is a blanket point on what else should we be thinking about, right, from their perspective. So it sounds like just maybe those two bullet points would need to come out at this point. I don't think this would be overly prescriptive to not allow them flexibility to come back with something that works. But by the same token, isn't just a blank check on our side that we're outsourcing this to another body and not having direct impact on how that's being conducted. How does that fit with your thought process on the recommendation?
So I guess the question I have is with that first point at scope. By the way, yes, everything else I think is I agree with. The first question though, the first point though, is scope of work methodology for conducting state-by-state review, taking into consideration the outline above, which is the state referrals. I guess the question I have about that is we're already doing that, well, I would suggest we do that with our referrals. So the question is, why would we want NASBA then to kind of duplicate that, right? So my first point was, let's evaluate our state referrals and see how well they're being addressed. So why are we asking NASBA to do the same thing?
So when I read this, they had a very, as I recall from our meetings, a very comprehensive evaluation. And what they brought to the table was their ability to navigate all of the differences between states because we are unlike our neighboring states. And so that piece would make sense. That was not necessarily a piece that we, I'll defer to staff, but it was slightly different than our following up on recommendations because of those nuances. So I would just point out that they brought in a layer of evaluation to it that was apparently quite helpful.
Manzella?
There you go.
So wearing, I guess, my staff hat now, some of the issues we would face on the referrals is, and where NASBA can get in where we can't, is I can refer something over, the board can refer something over to the other state. If they contacted me on the same end, I may not be able to release any of that information should the matter have gone through an appropriate process, whatever guidelines and practices they use, but they wouldn't tell me, and I wouldn't be able to disclose on my end how that investigation concluded. In the sense of, well, we assessed it, there's confidentiality within that NASBA can kind of sometimes at least systematically go in, look, not report us the data specifically, but say, hey, we went in, looked at these referrals, and because the states are more inclined to give that information to NASBA in that respect, because if I called, there's a likelihood we wouldn't get that.
So I didn't realize, I didn't know that. And so I would think it's important for us to know the disposition of the referrals that we send to another state.
We may know the disposition of closed, but we may not know whether or not they performed it in accordance with some type of within their internal structure. It could have gone over, and where some of it is to test that they went through the enforcement practices in their process, and some assurance to the board that it didn't just get referred over and then closed, that they actually went through whatever guidelines that were substantially equivalent to NASB's practice, so that the board can be assured that there's that level of due diligence done by the board. I'm not saying the board would do that, but I'm just saying when you say it's referred over and then it's closed, it leaves open we weren't able to test that in any particular
Yeah.
way.
Ms. Bowers?
One, that's consistent in most states. It's the referral or the filing of a complaint is confidential unless it's proven there was some wrongdoing to warrant a public action. So the referrals that we do that result in discipline or a public action, those we could find out. It's the other, which is the same in California. Just simply filing the complaint or doing a referral doesn't necessarily warrant on a case-by-case analysis that some action be taken. A state might look at the action we took, look at the underlying facts, and deem that that was sufficient to protect consumers in their state, taking all kinds of factors into consideration.
Mr. Petito?
Well, so then I would kind of amend that first point to be the focus on the California referrals.
I'm just totally not of a view that we limit this to just our own referrals, and here's why. I mean, you're relying on a state adopting guidelines to enforce discipline on their CPAs if necessary. That entire population of CPAs is able to be mobile, right, including into our state. For the reasons we just talked about, our referrals may be a limited population of what they have to look at, whereas if the population is broader in terms of an overall application of process, like was the case with round one of these reviews that we did, it just seems appropriate. And I know the legislation has specifics on our referrals because we wanted a connection point that our referrals were then subject to this overall process that's being evaluated. And that's why I'm getting hung up on limiting it only to that, and that's why I think I'm comfortable with the broader kind of methodology that's outlined here.
Just fun point. We just went through that process. We just finished that process in July of 17.
Right.
So we're doing it again.
We have a continuing responsibility for oversight, right? And so that's the framework that we're talking about. It doesn't have to be the exact same process, and that's why I think we need to get some views on what does that methodology look like. Mr. Franzella?
And again, as I maybe mentioned earlier, hopefully I mentioned earlier, I'm not stressing that they need to do it before July 2018 or even in 2018 or even in 2019, just that we have this framework in place, that there's this ongoing dialogue to demonstrate, and maybe they start with just that smaller group, because I think we've referred 4 is what's in that other report, or we've had 4 disciplinary matters. I mean, I think there's a lot of opportunity to work with NASBA to say, yeah, we just came off the heels of this very elaborate and long-going process from 2015 to 2017, and we're going to do this work here, and then maybe we do population kind of assessment going forward.
Some process.
And the process it's more about the process that you can present than the actual tangible outcome.
Chairman, I'm very comfortable with that. I understand that better. That's right. So I was concerned that we were finishing up July of 17 and then
do it again within a 6 month. No,
right. Exactly.
That's not what's laid out in this thing.
If I was another state and I get a call from California Board of Accountancy asking us to do this again, you might not want to go to your NASRA meetings again. Yes. So I get that. I understand that. I didn't quite understand that.
Is that a threat?
Some of the other state boards might.
But I mean, just to put a concept out there, right? I would think that you need a situation where every state is subject to a population review here. You may have a bucket of states that you'd say, based on the initial reviews, based on a risk assessment of those states, we don't think there's anything else that needs to be done there. Then there's probably another population that says, you know what, with these, there might need to be something similar to what we did before, and maybe it's rotated over some period of time. And then there's a middle bucket that you maybe think about some more. That's just one thought. So I think what we're looking for is a framework here.
Yeah.
And so as opposed to, we got 6 months, 7 months, 1 year, whatever, to accomplish, a review. Make sense?
Thank you.
A couple questions on the recommendations too. So we talked about almost all of it at this point. the whole internet disclosure piece, there was a lot of discussion about ALD, CPA Verify, and then what are these guys doing on their own websites? And, you know, that's, I think, what's in mind with that continued disclosure bullet that's in there. Peer review, any concept of how the application of peer review in all of these different jurisdictions fits into this overall process?
Ms. Salazar actually brought that up at a recent PROC meeting.
Okay.
I think it's something the board has to be cognizant of, especially in light of all the administering entity kind of consolidation that's going on, the AICPA taking over many programs. It could be something that if the board adopts this general kind of proposal, that's something that the chair and staff can include with discussion with NASBA to have peer review on their radar in some form, because there are states who are now contracting and giving up their peer review program to another state or to NASBA, and how is that impacting licensees' ability to maintain renewal, go through the process. I think it's a very layered and nuanced kind of issue that should be on their radar. I don't know how it affects us directly, but
Well, I think as long as peer review is still being
yeah.
affected by those jurisdictions, regardless of who's administering it, it probably, that's at the heart. So maybe that's more of an agenda or a topic for the next item we have on the agenda. But just something for us to think about, you know, as we proceed here. And then I think the last thing I would say is we'll have to really, in July and later, think about, given whatever methodology we hear from NASBA, how does the CBA engage with that? How does CBA staff engage with that? The same as we did last time, different than what we did last time? Is there some element of a CBA site review in connection with NASBA? You know, should something like that be part of the methodology that doesn't inhibit what we're asking NASBA to do, but allows us a little more insight than what we maybe did this last time? I'm not thinking one or the other is correct, but just keeping that on the radar of things we think about.
Yeah, I think we specifically left that off of this
I
particular
agree
one
with
with
that.
the intention of seeing what comes out, just like you said. And
Okay.
then it gives us the opportunity to, at a future meeting, develop some new assessment process going forward.
Perfect. Well, this was a agenda topic filled with lack of brevity. And so but we have a recommendation that I think I heard us modify a little bit, really to just remove 2 bullet points on the specificity on the state reviews and the sampling. But am I hearing a motion to approve that recommendation?
So moved.
Okay, so you're moving to approve the recommendation.
As modified by our
As,
discussion.
with those
Right.
modifications.
I think I heard you just second it.
Yes.
Okay, first from Ms. Salazar, second from Mr. Petito. Any further questions? Any comments from the public? I would call for the vote.
Katrina Salazar,
Yes.
Joe Petito,
Yes.
Dominic Franzella,
Yes.
and Jose Campos.
Yes. With that, motion carries. Thank you, that was very good dialogue, all kidding aside on the brevity topic.
Do I not get any questions? The next-
No, I was included with that lack of brevity, so I take full responsibility. Topic 3 is discussion regarding the mobility activity report. Mr. Franzella.
Thank you. So again, the purpose of this agenda item is to allow the MSG the opportunity to review and discuss the creation of a standing mobility activity report in the MAR, which I tried to come up with something else, but I have nothing. So.
What about mobility activity report?
So staff have created in your materials, the attachment to this item, the draft version of a mobility activity report, and it's really designed to just find some data points, some information that was being pulled from the annual report. It allows the MSG to track various activities that it may be interested in. It's pretty common. The board has it for its enforcement activity program. We have it for the licensing activity program or activity report. And this initial draft is just capturing data that was already included in the board's annual report or its recent mobility report to the legislature. It's by no means, this is it. Obviously, we believe if the MSG wants to utilize this report, it's an evergreen report, we would adapt based on any decisions made today, discussions made today, but as new items kind of fall into the MSG's kind of framework, that we would start adding those to the mobility activity report. So staff are recommending to the MSG that it adopt a mobility activity report with any recommended edits or additional data points that it believes are important for its tracking. And the ones in there right now are the out-of-state firm registration, stakeholder contacts, some information on website usage, and then the enforcement activity kind of aspects. And for those who, for the board members, you'll notice that it's no longer in the enforcement activity report. We pulled it out of our enforcement activity report and put this enforcement data information on this draft mobility activity report because it felt more appropriate here, because this is where the eyes need to be. These data points are already in the ear. They're just not called, they're no longer called out within the ear, and just the mobility stuff is now in the MAR. So with that, I'm happy to turn it back over to the chair and answer any questions you may have.
Okay, very good. Ms. Salazar?
Thank you. I do like this report, and I don't mind the acronym. But I do have a question on page 3. It looks like there's a footnote reference on the 4th line after entities for a 4th footnote, but I just don't see it included. So that would need to either be inserted or removed. Just a minor cleanup item.
I'll look through it. Thank you.
Grammar, please.
Sorry.
Mr. Petito, you had a comment earlier on out-of-state referrals or referrals to other states, and probably capturing that in here somewhere in that enforcement activity.
Well, thank you, that was my point, is just can we capture how the other states have responded to those referrals in this document?
Sure.
It sounds like we could use like a quantum of referrals we've sent out, right? And, or is it in here and
Yeah.
I'm just not observing?
Well, because I know it. The practice privilege revoked, that item there, number 4, the law itself requires that when we revoke a practice privilege, that we notify NASBA, the AICPA, and the state licensing board. So that particular number would be reflective. We could definitely amend this to demonstrate that more. It's practice privilege revoked and referred to other states. And then we can, with NASBA, or however that process kind of unfolds, how we're going to monitor the outcomes of those particular items.
So are you saying that through now, any referrals we've made to other states have been simultaneously revoked a practice privilege in our state?
Anytime we revoke it, we notify the other state. Now, how they act on it is, again, the subject of the prior discussion. And many of these were revoked, I want to say, at the beginning of 2017, mid of 2017, so they're still relatively newer, maybe for those states.
Well, would there be, and I'm just trying to think here, and maybe you've got a topic of referrals to other states, of which this is one, but would there be a situation where we might get a complaint on a out-of-state practice privileged individual? We decide there's nothing further we need to do within our state, but we would feel a need to still refer that matter to the other state?
If a situation like that arose, then yes, I think we could
Okay.
tab that, but
But
most.
through now, it has not been the case.
At this point, any complaints that are referred to us, we would perform the investigation and make a determination. But I don't see any barrier to then say we performed an investigation against one of your licensees and referring that to the other
Yeah.
state.
And I know on our side, we have this whole aging concept on how we track discipline investigations, other things like that. I mean, that'd be harder. I mean, you can certainly age out or think about communications that we have not heard back from other jurisdictions, but we still have the item on our open referred list, I guess.
Well, the other thing to bear in mind with some of these is, I won't speak specifically about it, the particular individual, but some of it was, the genesis was the other state. So the other state had taken discipline
Yeah.
on that particular individual such that we believed it was important that we take the same,
Right.
that we take a discipline. So referring it, all we're really doing is referring it back, saying,
We took
we're
action.
required to refer it back to you, but we took action. So there, I wouldn't anticipate that there would be something further to occur on the backside because the genesis of our discipline stemmed from there. So I wouldn't expect it just to continue to be this cycle.
So we'll have to think about what the right categories on referrals to other states are, right? Because some of those they originated the original referral or the original action that we're monitoring, but, okay. So agree with that concept. Any other topics on here that, I thought we could use a section on, and I don't know what would be included there, but something on sort of NASBA developments, right? I mean, NASBA certainly is doing things around the country, and are there any things that we're seeing in their communications that would be worth highlighting from a mobility standpoint? Similar to the last discussion, peer review. Is there anything on the peer review front or developments that would impact or be appropriate for us as an MSG to be evaluating as to, does that have any implications for what we might need to do? And lastly, the internet side of things, right? That was such a big piece of things. Any ALD, CPA Verify, or other internet disclosure matters that developments, and this is not meant to be a summary of what every state is doing, but rather has something changed that might require, consideration as a board.
Absolutely. We can add all of
So
those.
those would be topics I'd jot down. Overkill on any of those?
Maybe. I'm gonna throw that out there. I do think we have a standing item on our agenda for NASBA developments on, if there are things for standing reports from committees.
So we're not talking about, just broader CE
Maybe when you say
things
NASBA development.
as it relates to mobility, enforcement practices, things that are relevant to our considerations of mobility.
The MSG did have a standing item for
I
a
see.
long time on NASBA activities, ALD, CPA, it was very specific to activities associated with mobility. So I could see something similar here. And the other thing this doesn't have, because we just didn't have anything at the time, if it's anything like the enforcement activity report and the licensing activity report, there's usually a section on highlights, things, occurrences that, don't really fall within a particular area, but, or a particular category already identified that we can add on. So it just doesn't happen to have anything at this particular time. But there'd be another
Okay.
section.
I appreciate that.
Anything further on the mobility activity report? Any comments from the public? Okay, I don't think any action needed, but appreciate the draft and the friendly editorials you got from the
Do
committee.
we
here.
need to adopt this to?
Think so.
Staff put it in there as an adoption, but I think for all intents and purposes, if you just direct us, like you just
I
done.
think you just did.
We can do that.
Unless you want to make a motion.
No, sir. I don't want to get into your time.
Thank you.
Too late. Topic number, agenda item 4, Ms. Moasagi on objectives related to the MSG.
Yes, good morning, Chair and members. The purpose of this agenda item is to provide the MSG the opportunity to discuss and take action to revise its stakeholder objectives. At its July 2014 meeting, the MSG established 2 stakeholder objectives, which are in your attachment, and requested that they be provided as an agenda item at every MSG meeting. At that time, the MSG used the CBA's 2013-2016 strategic plan as guidance regarding the definition of stakeholders. As the MSG has completed all legislative milestones and embarks on its future role, there may be new stakeholder objectives for the MSG to consider. The stakeholder groups represented on the MSG include consumers, the profession, and the CBA. Additionally, as the prior definition of stakeholders was not an all-inclusive list and was viewed broadly, the current definition, as seen in CBA's 2016-2018 strategic plan, provides more detail and may prove to guide additional objectives such as consumers of accounting services who require audits, reviews, and a wide variety of related tasks, lenders, shareholders, investors, and small and large companies that rely on the integrity of audited financial information, and governmental bodies, donors, and trustees of not-for-profit agencies that require audited financial information or assistance. Regulatory bodies such as the SEC and the Public Company Accounting Oversight Board, local, state, and federal taxing authorities, retirement system, pensions, plans, and other state boards of accountancy. Staff will update the attachment to include new objectives identified by the MSG, and we don't have a recommendation, and I'd like to turn it over to Mr. Chair.
Okay. Comments from the committee? I think the stakeholders defined pretty comprehensive. The objectives, I think the two objectives that were there seem to make sense, and I think continue to guide everything. The one item to think about is the continued, or the disclosure of disciplinary information might be appropriate to lay out as a separate objective. I mean, we already have assessed that all states have adequate enforcement, which is all the guidelines and all this other stuff we've been talking about. But assuring that disciplinary history, you know, there's words right in the law that I think would be appropriate to include if the committee feels so inclined.
So, how about we add something along the effect of help consumers of the accounting profession in this state access to disciplinary history of CPAs? Too broad?
Well, it may be
Skinny
too
that
specific, or we could just say, assure that disciplinary history of licensees is publicly available through the internet,
Oh, I like that better.
you know, which is just the exact words out of the law.
I like that.
And then
Is that a
that
motion?
continues to guide what we do. Yeah, sure, I would move that.
I'd second it.
I'm so honored. Any further discussion on that? Comments, input from the public? The vote?
Jose Campos?
Yes?
Dominic Franzella?
Yes.
Joe Petito?
Yes.
And Katrina Salazar?
Yes, please.
All right, motion carries. Item 5 is public comments.
Joanne Hinkle.
Thank you.
I'm
Same
getting-
rules apply as previously
Yes, yes.
read.
And I like your two styles. I'm getting the system, I'll turn it in as an agenda item after I've turned in these 8 petitions for rule modifications and changes, and also how are disabled rights protected during the complaint process in CBA, so the disabled are not just brushed away as bothersome bugs, and how the CBA laws protect disabled rights from CPA abuse, okay? And that's why I'm submitting my laws. Okay. One law was suggested by the CPAs I interviewed. Strong recommendation of CPAs that I interviewed. They want to preserve a good reputation among CPAs. CPA should not allow trust CPAs, or CBA should not allow trust CPAs to use non-standard formats for trust accounts for the mentally challenged, young or old. Change to an innovative or less preferable accounting method with improper presentation leads to confusion, misleading financial statements, especially for the mentally challenged. In addition, CBA does the consumers in the state of California no favor by going soft on trust CPAs who create innovative trust accounting methods that hide the drain of income instruments for the mentally challenged beneficiaries so the family members can keep the money and place the mentally challenged beneficiary on public assistance, where they don't want to be. They want the love Grandma and Grandpa left them. It is then the taxpayers in the state of California that become burdened with beneficiaries that were provided for by wealthy settlers before the grave swallowed them up. Mandating trust CPAs to provide trust accounts using standard accounting methods and also the method that is in the trust. The CPA did not use the method that the settler said should be used in the trust, and CBA didn't care. They said it was not a violation of the Accountancy Act, which is another one of my rules, that the trust CPA has to follow the accounting procedures method that the settlers had requested be provided for their beneficiaries. And he didn't, but CBA didn't care. Okay, next law. Also, the CPAs that I talked to wanted to expand from the autism to the seniors. And they said there's 2 categories you have to be careful about. Okay, also your CPAs are becoming conglomerate financial institutions. They are doing loans, they are doing exchanges, they are doing loans to the trust, and leaving the loans off the books, by the way. And I just happened to find them in the county board of the records department. And CPAs led 3 of his clients to invest in a scheme that made 3.3% interest per month. Turned out to be a Ponzi scheme. They all went to court, and the CPAs provided 2 loans to the trust. Everything financial was done within the CPA's financial conglomerate. So it was like impossible, and he kept the books. So what are your laws about CPAs who are growing into financial institutions? Who covers them? The banking industry, the loan industry, CBA, their license. And so it's very confusing, and it's a very tight-knit circle, which it's hard to find information. And CBA did not care that the CPA did not disclose to beneficiaries that he was loaning money, negotiating, doing absolutely everything for this $30 million trust within his conglomerate. And so I think that there needs to be disclosure rules, because the mentally challenged need things clear. Am I 5 minutes up?
Almost.
Well, I covered these 3. I have 2 more. But anyway, so I'm going to turn all these in, and I'll ask for a future agenda item. And I hate to bring you down from your high level. You're so intelligent. You're very intimidating. But if you're intimidating to me, I can't even imagine what you would be to a mentally challenged person. They have no hope. I used to hear this phrase, someone could slit your throat and not even draw blood. I had no idea what that meant. But now when I see the accounting profession, I know that a throat can be slit and there's no blood to be found, because I have searched and searched and searched and searched trying to find drops of blood. And especially when it's all within a financial conglomerate, it is impossible to find unless there's laws in the state of California that don't allow a CPA to do these things, that his license can be in danger. Right now, as you have it, you say the 27-year-old Billy case or whatever means that a CPA cannot be held responsible but even the Billy case even said known third parties that a CPA is responsible to. Trust beneficiaries are listed on a sheet. The CPA knows that they are known, they have the names, they invite them into their offices. And that Billy case was before the 2000
Thank you for your input.
Okay.
Appreciate it.
Before a financial crash,
Thank you.
and before Bertie Madoff.
I think that was our last agenda item. Anything further? We are adjourned.